Do you think life is simpler as time evolves? For some, it can be more complicated when facing issues about health, estate plans, probate, long-term care, and more. That's why Attorney-CPA Joe Cordell hosts ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of ElderTalk, continuing our focus on this pandemic that we know has captured your attention as well as ours. And we want to provide the most help that we can during arguably one of the most memorable periods or events in our lives, wouldn't you say?
Absolutely.
Mm-hmm. Yeah.
It's so surreal.
And with us today, of course, is Jill, our ever-present moderator, co-host, assistant, commentator, whatever else we need at that moment.
Yes.
And you'll recall from our last show, we have Teresa Yao. Teresa is an attorney at TuckerAllen. She focuses exclusively on estate planning. And so we want to take this time and dedicate it, interestingly enough, to the sponsor of this show, TuckerAllen, to talk about how is it that estate planning relates to this crisis in our lives. And I got to admit, it's almost embarrassing that during the show we give so little time to actually talking about the application of the law as it relates to the coronavirus.
Right.
And especially the importance of estate planning. And so I feel guilty that we've probably done, maybe one full show spread out over segments of several shows in the last month and a half since this lockdown in which we focused on this subject. And I believe this is arguably the most important thing we can talk about because we're not doctors. Mm-hmm. So we know that you are getting information from a variety of sources on the medical scene. There's wonderful information out there. I'm really impressed. I'm learning who some of these key players are around the country when it comes to healthcare. So that's not really our expertise. We like to bring in people to be of help to you. But what we can do is talk about the thing that we know a lot about, myself included. So today we want to focus on what should you be doing from a legal perspective to protect you and your loved ones?
That's why I'm so glad Teresa is joining us again. And, this pandemic should serve as a reminder for all of us because absent a pandemic, it's so important that we have our affairs in order because we don't know what is going to happen from one day to the next. We've all had loved ones, friends who have just, had something terrible happen like a stroke and they're mentally incapacitated and they need someone to make those decisions for them. And if they don't have those documents in place, it can be quite challenging.
Yeah. And Teresa, among the things that clients think the most about, tell me if you agree, is who and how will I be taken care of for the balance of my life? I mean, estate planning is important if you define that as, who gets my stuff in what way. And that is very important.
Right.
Mm-hmm.
But when it comes to urgency, I think most of the people that walk into the door, TuckerAllen, would you say that priority number one is to take care of the balance of my life and then to assure things go as they should?
Yeah, absolutely. I think in terms of the urgency of the situation, what the pandemic has really surfaced up to people's consciousness. The documents that people are really asking most for are the powers of attorney documents. And those are the ones where they get to kind of make sure that there is a plan in place while they're still alive. But if they aren't able to make decisions for themselves anymore, who is there who would be able to act on their behalf?
And just to make this real for people listening, this is how imminent and how important this situation could be. Imagine that you come down with this coronavirus, and let's assume that you find yourself in an emergency room and you go to initially a general care, a medical floor focusing on COVID-19, which I think is the way hospitals are doing is they're setting aside particular floors.
Right.
Mm-hmm, yeah.
And then let's say that your condition worsens. So at that point, several things could happen. You could be placed on a ventilator, perhaps prematurely even, perhaps even unnecessarily. And not that doctors don't know. They know as much as the information is available to them. But still, it might be that you would survive without. It might be that you wouldn't. You don't know. But some people feel very strongly about going on a respirator.
Right.
Yeah,
Or a ventilator.
absolutely.
I mean, they feel that this is not something that I want to go through, and they just are very insistent. Now, I'm not saying I agree with that, because I think as long as a ventilator may be your last best hope, that's what you want. But some people have very strong feelings about it for various reasons. So this is the document that would determine what happens. And it's not simply a matter of checking boxes on a form. A lot of people think that whenever, Teresa, you mention a durable power of attorney, they're confusing that with this form that are handed them that lawyers prepare for every medical facility in the country. When
Yeah.
you come in for any sort of care, you're handed a form. And that form, you check 1 or 2 or 3 boxes. That is not really what we're talking about. We're talking about giving somebody authority. Talk a little bit about that.
Yeah, I mean, so within the kind of hospital context, the 2 estate planning documents that come to mind are the healthcare power of attorney and also the healthcare directive. And those are legal documents. It's not like the DNRs that the doctors are really giving you.
Yeah, tell them what DNR is.
The do not resuscitate orders that the doctors are giving you. The healthcare directive, that is your chance. It's like a testament that you make to your physician about what you want to be, how you want to be taken care of in end-of-life care situations. With regards to COVID, some people in this situation, they want a ventilator to still be administered. Some people feel really cautious and afraid of intubation. And this is kind of your opportunity in that document to express directly to your doctor when you still have the chance of how you want your body to be taken care of in that circumstance.
So it's very personalized to meet your wishes.
Yes.
Correct?
Yeah.
Okay, very detailed.
And for people who've deteriorated a lot, it is an option even short of the doctors concluding that there's no further point in keeping you hooked up to this intubation or whatever the mechanism may be, maybe a respirator. Then there is the option of giving you simply palliative relief, which would be, for example, like morphine, right? Or something where, in other words, you can leave the world without being in pain and discomfort and potential claustrophobia, which some people experience from this.
Yeah.
Or you can say, no, I want to have every shot in the world to the very end.
Yeah.
And there is no right answer here. But I think some people are affected by their age, by their general condition of their health. They may feel that I'm hovering at this doorstep anyway, so why should I suffer unnecessarily?
Right.
But these are important decisions that you can handle them a couple ways. One is you can do a living will, which we do both typically at TuckerAllen,
we
right?
do. Mm-hmm.
So a living will is kind of where you do fill out this somewhat detailed expression of what you want to happen. Now, the danger of that is that can you cover every possible scenario? And that's pretty tough to imagine.
Sure.
That. So there is an alternative to simply writing down on this document your rules, your requirements, and risking that they may be incomplete or may be somehow inconsistent or misunderstood. There is another option. That option is to empower a person to become the gatekeeper of this decision. So you choose a person that you entirely trust, and that's what, Teresa, you were referring to is a durable power of attorney, is where, as a power of attorney, that phrase implies, it means that you're letting someone have the power to say, okay, tell me what the question is. So whatever the question is about your health that have come up, some of which we can't imagine to put in this document, right? Mm-hmm. So a living will does have its shortcomings. But giving a living, breathing, reasoning person whose judgment you respect this authority allows them to really handle any question. So anything that comes up relating to your health care, the hospital will turn to, or the healthcare provider will turn to this appointed attorney, so to speak, as to this subject, and we'll ask them, so this is the situation, tell us what the patient wants.
Right. And it should be somebody that you trust with your whole life, someone that would act on your behalf, knows you so well, knows you better than anybody. Wouldn't you agree?
Yeah, yeah. And who do we had last week, the guest who was this marvelous physician from St. Louis U.
Dr. Morley.
Morley, he's a geriatric specialist. As a matter of fact, internationally known. But, he was emphatic that, and I think he was speaking to this from his perspective too, what he thinks he personally would want. And he said, I can't imagine going into a hospital, being in the final stages of this condition, and not having some way to communicate my feelings about how I want my care to be.
Right.
So, I mean, he got it and he understood it. And for him, it was a very real question. So his passion just in part suggested to all of us that we should bring this topic back up this week.
Yeah, I think so. And I think that's something, most people don't want to think about. We don't want to think that something terrible is going to happen. And, we certainly don't want to alarm anyone. But we do know things do happen, and we need to be prepared.
Yeah. And that's right. We know the good news is that the fatality rate, the mortality rate from this disease is, experts argue, between, well, not zero, but less than 1%, maybe 0.1%. I don't think that the argument now is that it's much over 1%, if at all.
The projections, are way down compared to what they were. So that is some good news.
So the flu is 0.1%, and some say it may be just a couple of tenths of a percent higher. Others say it could be, not many say it's lower, but maybe it's closer to 1%. But if you think about that number, the odds are pretty good, except when you refine the number for further information, such as the age of the person, then obviously that probability goes up.
Yeah, and with underlying health conditions.
Yeah, or I think with this disease, how it's different from other diseases that might have a higher mortality rate. The infection rate is so much faster for this disease than others. So I think that's kind of
it does. It's almost concern. Like a wildfire. It's amazing how, unlike when you think of people say, well, some people die from the flu, but I think the progression with the flu is, this sort of relatively gentle sloping deterioration. And whereas the thing about this is you hear that some people may come down with this and be relatively stable for a week and a half and then just plunge, or they may plunge within a day or two of getting it.
It's unpredictable, isn't it?
Yeah, it really does move fast and furious in particular people.
And I guess with that unpredictability, that's why estate planning, just to loop it all back, is important because, I think of estate planning as kind of more like an insurance. We have insurance policies for different areas in life, and estate planning really is like that all-encompassing one that takes care of your finances, but also your health and your loved ones, especially in times of uncertainty. So.
Right. And what can happen if you don't have anything in place? Can we talk about that? What are some of the situations you could run into?
Yeah, so that really is the worst case scenario. And I think, sadly, for a lot of people, that's a very real scenario that they're dealing with right now. If you are in the hospital due to COVID or whatever other illness that you might have, and you don't have any estate plan in place, you don't have powers of attorney documents, you don't have wills or trusts, that's a very scary situation to be in, because that means you don't have much control in a situation where you're not able to express what you want, and other people are making decisions for you in cases where you would have been able to express those decisions if you had just done a little planning beforehand. So you're leaving your kind of life and your decisions into the hands of your doctors or into the hands of the court system.
Yeah, and often it happens informally too, doesn't it? There's kind of the law school exam question on this about, who would have authority. And, of course, we're all taught that, and we tend to think, well, things happen the way the law says. So if you haven't created a document that empowers someone to make your decisions for you, then that means that somebody has to go to a courthouse, which incidentally, it's very hard to get hearings in the courthouse. I'm curious right now how this is being handled. And I've not looked into this specifically, but I hear from the lawyers at Cordell & Cordell that it's difficult to get emergency hearings, that it's very discretionary on the part of each judge. So it's kind of judge-driven. But this is an example of a circumstance in which it would normally be regarded as an emergency hearing. So you have somebody who has become incompetent, and in our case, it means they've contracted this virus, their conditions deteriorated, they're no longer in a position to make decisions about their lives, to sign documents. Think of all the things that on a daily basis we make decisions about that require that those be directly from us by way of a signature or a thumbprint or however we authenticate our signature. lots of things in our lives require that. Now imagine suddenly we can do none of that. So what happens to all the things in our life that are supposed to be going on? Payment of rent, funds that are automatically deposited in some accounts that would typically be moved over to an investment, maybe other expenses outside our health care. I mean, there's so many things in our lives that require our authentication. And once you're no longer capable of authorizing something,
Right.
then suddenly someone else is going to either do it informally, which we'll get to in a minute. I think that often happens, Teresa. We don't, those are the people that don't go to the lawyers. And I think often there are people who are poor who simply handle things, on an ad hoc basis. But the proper answer to the question is when you're suddenly incompetent, is that somebody has to be appointed. The law has to say, okay, you can stand in. And if you haven't signed a document which you've made that decision, then somebody will be appointed by a judge, assuming they can get into court. If they can't get into court right now, then it means nothing in your life is going to happen.
Yeah.
Now, doctors will probably charge ahead because they have to. Now, you don't know what they'll decide. Their decisions may be ultra-conservative, where they decide to keep you intubated and on some sort of life support for months beyond what, God forbid, you'd want or anybody else in your family. So another approach could be they ask somebody in your family. In other words, it's all up in the air as to your fate in this world.
It's a gamble, really.
Yeah, it's all up in the air. Now, the informal answer I mentioned a while ago is expressed in a number of ways. One is that it is sometimes a result of doctors coming to the hallway and talking to families. Not that gives them legal authority, but they have to do something, and there is no document, we'll assume, to speak to that particular situation. Now, there may be that form they signed when they walked in where they checked a couple of boxes that were prepared by the lawyers for the hospital, not your lawyers, not protecting your interests, protecting the hospital's.
Hospital, sure.
So that document will address some circumstances. But, this is a continually moving scenario in which the conditions change, the questions that arise are changing, access questions and other things. So it's really an informal process in which you leave it up to chance, as you said, who decides if you've not taken the time to prepare this document. But anyway, so let's assume then that as to your financial affairs, which if they're significant, if you're middle class even, then these numbers are significant and the magnitude of those accounts and the issues at question are of sufficient significance to where you can be sure that all those intermediaries involved, all those financial institutions are going to be very formal. They're going to require authorization and they're going to do, what is the technically correct thing, whether it's in your interest or not, because it's in their interest. And if you don't have a court order in which somebody has been authorized to act, then no action will take place. So I don't know how this is being handled now because I'm confident that these cases are not being heard at the pace they need to be in places such as New York. Now, thankfully now, it's good that we don't have many COVID deaths in Missouri because we don't have the level of court access now that would be required. Now, we can assume that maybe judges would step forward and the machinery would kick into gear to start handling these things more expeditiously as the need arose. And I do believe that's very foreseeable. But as you were suggesting, Teresa, it's not a pleasant process even when you get in the court door. So you're frustrated when the court door is closed on you and your life is shut down. The important things in your lives can't be addressed because no one has authority. You're incompetent. That's not good. So I guess the only thing that would be, I guess, not as bad as that would be they open the doors, they let them in. Now somebody is paying out of your estate a significant amount of cost for a judicial proceeding in which experts are present, in which testimony is taken, in which somebody is appointed, and they're appointed by the court to make decisions for you, a guardian and a conservator, the conservator to address the financial matters, the guardian to address the personal care matters. And this is all funded by you, and it's a very cumbersome process that requires reporting back to the court, continually spending more money from your estate. And the person who's chosen may not be the person you would have wanted chosen.
Right.
It's out of your hands.
And can you imagine, you mentioned before that, the doctor can speak to family members and not that they necessarily have a legal right if There hasn't been some documentation, that has occurred, but they get some sort of idea. But can you imagine how much worse it is for individuals that don't have any family members? You're talking about a senior citizen that's maybe widowed, never had any children, and they're all alone, and no planning has been made.
Or if that they do have family members, but family members aren't local and aren't able to be with them. And obviously they can't travel to be with them right now.
Exactly. That is a really good point.
Mm-hmm. And you really wonder, how does that play out? Mm-hmm. I mean, I guess it's a case-by-case basis. And like we mentioned a moment ago, I was going to come back to was the fact that you do have people who would be considered poor, meaning, they have some assets but not much. They may own a piece of real estate, but many people at that level, because of the cost of using the court system formally, and some because they don't want to hire lawyers, though in this case the cost would be very little. We'll come to that before. Let's make sure we talk about that, Teresa. But so the cost here would be very little, but there are people who have it just a distrust and perhaps a disinclination to deal with lawyers and that sort of planning. So they go about their lives and do things on an ad hoc basis. And so when in a case like this, though there may not be a court order allowing them the right to have custody of a child and be able to make decisions for that child, they will just go ahead. Family members will come in or neighbors, and they'll continue to function that way without any lawful authority until they butt up against something that requires it. And sometimes, where I grew up in Whitley County, which is in Appalachia, you didn't never butt it up against anything because nothing ever required it. So you would find people raising kids who were, they didn't at no point had lawful authority with. But the healthcare providers would just nod. I mean, they saw it every day. So they didn't question it. But for the most part, you're going to butt up against institutions here that are going to require you to take resort to a court. And so avoiding that planning is just postponing the inevitable. And some of these same people, incidentally, some of whom I'll have to admit are in my family, will, to avoid probate, most of us, again, we realize that, you can't avoid probate. We should talk about this in a second, Teresa. But some people don't do any planning, right? So the same person that maybe went out of the world without any document saying what they want. So what happened, happened. So they're gone, and now their stuff is left. And we'll assume not a lot of stuff, because most people have a significant amount of things. They do tend to do some sort of plan. But then there'll be a few pieces of real estate. So not being inclined to have gone in for a durable power of attorney to take care of the balance of their lives, that same mentality of the family is to say, well, what do I need to do? Do I have to really deal with probate? I'm just going to go ahead and take possession of the property and start living in it and using it. And when the tax bill comes, they pay the taxes, hopefully. What they do or they lose the land, right? But I talked to a cousin of mine. I was at the Kentucky Derby about 4 years ago, and he was telling me, I knew that my great aunt had died, and that had been a number of years ago. And he was talking to me about this farm, and he said that, he was wanting to do some sort of improvement on it, and the bank was resistant because of the title. And I said, well, what's the title in? And it was in the name of his mother, and she had died years ago.
Oh,
and,
so he had no legal right to it.
So, I think that happens a lot.
I do too.
Yeah.
So, somebody would have had to gone to probate, right? Because, if you die without a will or even with a will, in those two scenarios, the only way you're going to resolve that is to go to probate. And some people in some parts of the country, and I think sometimes it's socioeconomic, they just don't resort to the courts until someone in a blue uniform tells them that they have to go to court.
I've seen those situations. In fact, the neighborhood I grew up in North County, I saw several of those situations. A parent would die, the child would take the home over. And again, when something like that would happen, if they needed a loan or something like that, they had no legal right to the house. Yeah,
and it can create just a mess of title. Down the road, when it comes to trying to sell it or something, you're going to spend a lot of money clearing up that title. And there may be subsequent claims too, because it wasn't settled in you at the time that it should have been. So other things happen. People die, people are born, and suddenly other claimants emerge from the woodwork. It's just always a bad idea.
It's a really
Complicates
drawn
matters.
out process
Yeah.
to finally deal with it at that point.
So, and I'll tell you, for winding this story out, this cousin of mine I'm telling you about was pretty old. I mean, he was probably in his 80s. So I can tell you, he's going to leave this world, and knowing his son as I do, two sons, knowing them as I do, there's a good chance that will not be probated. So you're talking about generations, and I don't think this is
Wow.
unusual. I really don't.
Yeah.
In
Yeah.
Appalachia, especially, but maybe in parts of St. Louis.
Oh, I'm sure. Yeah.
I mean, if an older child can live there, say that the child, we use that word, is 60 years old when his or her mother dies, and it's in his or her mother's name, and they live there for the next 20 years. They don't go to probate because they don't need to. They're living there. And then they go out of this world. So now you're talking about 2 generations in which there was no probate. And some people listening to this are thinking, well, okay, is that a big deal? Yes, it's a big deal.
It's a complicated mess is
That
what
just
it
sounds
is.
like a headache to me. when I
Yeah.
hear that.
I know. It makes my
Wow.
head spin thinking about that. But yeah, that does happen. Absolutely. And, I think, too, with unemployment soaring, many people can't afford an attorney right now. That's what
That's a
they
big
think.
issue.
And they might resort to using something from a website. But, estate planning is very complicated, and you want the expertise of an attorney to kind of help you navigate through this process.
Yeah. What would you say, Teresa?
So yeah, I know that there are those online services that have these forms available, these like boilerplate forms that they have for different types of estate planning documents. I think my reaction to those is that those are helpful only if you are so cookie cutter, because they are like broad brush stroking families, relationships, individuals. And then why estate planning attorneys are available and why they're good to talk to consult with is because they are there to answer like tailored questions that you might have.
Yes.
The opportunity to actually create an estate plan that's customized for your life and your relationships, your loved ones. And especially now more than ever, I feel like families and relationships are different. There's a much greater variety than they used to be. So I think talking to an attorney is a much more effective way, and like probably long term, it'll be more helpful for you to have that estate plan that way rather than through the online services.
And they help with, when it comes to titling, like real estate and
yeah.
vehicles. And I can remember this was a very good example. Right before my brother-in-law died, he signed, it was something, it was the title for my husband to take over this vehicle. And it wasn't an expensive vehicle by any means. Well, anyway, we learned afterwards when my husband took it to the DMV that his brother signed on the wrong line. And this vehicle that wasn't worth anything had to go through probate for my
gosh.
husband to get rid of it. He was ready to just junk it somewhere. But that's, something, this vehicle that was not worth anything caused this big of a headache.
Let me tell people, though, who are in a position where maybe they can't act now, or a loved one has passed away, but there weren't that many assets. The one thing that you can do that is encouraging and you should consider is if you have less than $50,000, I think that's the cutoff still for small estate. Teresa, is it still around 50?
It might be 25,000.
Well, it could have been lower.
but,
So
yeah.
so let's just say check with the courthouse, because the number has changed. But let's say it's between $25,000 and $50,000, 50 on the top. So if you do happen to have assets that are of no more value than that, then you can simplify this process. So that's the good news for somebody who is poor, for example. I mean, there's no reason to be in the scenario that we were just talking about, where you do nothing. But really, property values being what they are, not a lot of people are at less than $50,000, not to mention $25,000.
Right.
If there's any real estate involved.
Yeah.
So the point is, it's very easily corrected. You can avoid that situation entirely. But for those who do find themselves in a situation such as you just described, Jill, and if it's less than $50,000 or $25,000, then for those it could be very fast. And call the circuit clerk or the probate court's clerk, and they can answer a question about what the threshold is. This is called small estate administration. And so your question is, what is that threshold? But the point is, there is one, and if you're below that, then you don't need to hire a lawyer. It can be very simple, very fast.
Right.
So just something for those listening to note. But whenever you want to avoid the whole probate process, there is a way to do that. And some people think it's a will, and oddly enough, probate was created to ensure that this piece of paper that somebody in the family is waiving and brings in the courthouse and coincidentally always says that they inherit everything, the court has learned to greet that with skepticism. So you have these elaborate requirements regarding how wills are executed, that meaning that how they are properly signed with witnesses and formalities and whatnot. And some people think that that seems very unnecessary, but in reality, it's intended to protect somebody who's 6 feet under the ground. If you're vulnerable, I can't imagine you're being any more vulnerable than when you're 6 feet under earth. And so it's having rigid rules to protect you. And so the probate process does two things. Number one is it authenticates this piece of paper and says, is it real? And so if somebody says, well, I think that it's a forgery, or somebody says, well, it may be that's the real signature, but there was undue influence. Well, the court wants to hear about that.
Right.
Tell us about that. Was this old person defrauded, by a maid or somebody? We've all heard those stories, or that greedy family member who's moved in when they were senile and took advantage and took them to a lawyer and had them sign new documents. I mean, the court wants to hear all that. So that's one thing is being sure that the document's real and getting it to the person that the deceased wanted to get it. But the other important purpose for the rest of the world is being sure that creditors get paid ahead of the beneficiaries. So part of probate is to get out notices to creditors and to people in the community through legal periodicals or newspapers, whatnot. And it says, so-and-so's died. If you have a claim, here's where you file it. Notify, call this number, use this address. And it gives everybody the chance within a window of time, what is it, 6
months.
6 months, within a period of 6 months to come forward.
Mm-hmm.
And you publish that just in any type of publication? Is that how it works?
Usually it's the legal periodical for that county. But usually you have a couple of options. The whole idea is to get it in front of the public in a meaningful way.
Okay.
So once 6 months has passed and creditors have had a chance to come claim their money, then the law says, okay, at that point it's fair to close the window, meaning that window of opportunity is closed. Now we can distribute the stuff that's left to the beneficiaries, and the matter is settled. Creditors can't come out of the woodwork anymore and say, wait, I have a claim here. At that point, it gives closure to the estate. So that's the purpose of probate. And if you hear the purpose, you think, okay, that sounds very reasonable. But the point is it's unnecessary, right?
Yeah, you can avoid probate. You can avoid all these assets going through probate. And I think we kind of touched on it earlier. Probate can be a very arduous process. It can take over a year. And part of that, administering all these assets through probate takes a chunk out of your estate because Missouri has statutory fees that they charge to administer all these probate.
Lawyers write the law, right? So, and they are. It's prescribed by statute. And you can look up the statute, which 452 something. Anyway,
I don't remember.
Look at you knowing the number.
I would have really impressed the listeners. But the point is, you can look up this statute, and the statute, as you said, it describes exactly what the lawyer gets, and it describes what your personal representative gets. But here's what's interesting about that language. It never ceases to amaze me when I talk about this. If you read those percentages, which seem pretty generous out of the estate, if you read that, you think, wow, that's the legislature has written lawyers a pretty good deal. But if you read the language, it actually says this is the minimum. It says this is the minimum that lawyers can charge. And it specifically says this should not be regarded as a ceiling. So it's almost like if you were able to write the law to cover your customers having to do business with you, what would it look like? And that's what it kind of looks like.
Right.
Yeah.
So describe the alternative. I mean, the opportunity with trust.
Oh, yeah. So trusts are that instrument that I always say the big shiny advantage of a trust compared to a will, because wills do not avoid probate. Trusts, anything, like I kind of go metaphorical here. I think of a trust as like a legal basket that we create for our clients. And then our clients can put their assets into this basket, and anything that they put or title into this trust avoids probate. That means that savings that you are not paying to probate court, that percentage of your estate is actually transferred to the people that you want to receive those assets.
So I just want to make sure I'm clear. So with probate, you do have to notify creditors. You do have to put that in some sort of publication. But if you have a trust, you do not have to do that. Is that correct?
So with a trust, essentially the ownership just like passes. So if you are this like trustee and a grantor of a trust, anything that you put into this trust, you still remain the owner of this trust. And as you pass it down, like the property is just passed down minus all the probate like pain, I guess.
Okay.
I don't know if I'm answering the question correctly.
Yeah, it's like it transitions immediately. So you move it to the hands of a trustee. And we won't complicate it by making it revocable. Okay. So we'll say that
for another show.
We'll say though that you assign ownership to a trustee, and so the trustee owns the assets. But the trustee's duty is to own them according to the terms that you dictate. So the trustee cannot change those terms. The trustee has to follow your instructions. So at that moment, it's not yours from the law's perspective.
Right.
So what's wonderful about that is you're still enjoying the benefit of the assets, using them pretty much as you want to. So all goes wonderfully. Your life is as it otherwise was after you've created this trust. But the real power of it isn't felt until you pass away or you become incompetent. If you become incompetent, you may not know it, but that trust has come to the rescue.
Right.
Because you've already put in the rules and everything for your care. It's like a super durable power of attorney. So a durable power of attorney, we've talked about how wonderful that is, but you can bolster it or even substitute for that a good trust where you've given a trustee power to take certain actions if you become incompetent. Similar thing. Mm-hmm. This trustee, though, has these assets. The trustee is the owner, according to your terms. So you pass away, and guess what's in your estate? Well, nothing that you put in the trust because you didn't own it. So everything that you put in the trust will continue to be in the trust when you die. So technically, at the risk of sounding a little morbid, the trustee could, an hour after your death, distribute the assets to all of your loved ones. I mean, an hour.
That quick, right.
That quick. No judge, no lawyer, just immediately. If it's Uncle Bill, that's the trustee, or a particular son, or a lawyer, could be, but it doesn't have to be anybody such as that. So let's assume you die at 9 o'clock a.m. There's nothing legally that would prevent this person, we'll call it, say, your chosen son, to do this. So he could meet with the family an hour later and say, okay, I'm going to sign deeds, and here, you get this house, you get this house, or this house goes to three of us, all three names on the deeds. In other words, those transactions can take place immediately. No judge, no court, no lawyer.
No headaches.
Yeah, no headaches.
And those instructions are ones that you laid out beforehand on how you want the trustee to distribute.
Yeah, and
these
that's
assets.
the most important point.
Yeah.
Is that it is your rules that this person is following, not their rules.
And, I think it's so wonderful during this time what TuckerAllen is offering, with the durable power of attorney. I'm sure you've heard on ElderTalk before. And Teresa, if you could speak to that.
Yeah, so for the most urgent planning matters, we had talked about the healthcare power of attorney and the financial power of attorney. TuckerAllen is offering complimentary powers of attorney services. So you can just go on our website, make an appointment. Our phone number is on the website, too. If you want to call us and make that appointment, we can set up free powers of attorney for you.
I mean, that is a big deal.
Very
I
big deal.
Some people may be thinking, oh, okay, so a free durable power of attorney. It may think that is commonly handled in this way. If you have access to something holding itself out as a durable power of attorney, it's probably a form. And if it's free, it's got to be a form.
Right.
And the reason is that, to have a lawyer sit down with you and to say, what is it that you want on these particular topics, so that you're getting something that's truly customized for you. And your answers are not likely to be the same as a person who might be sitting next to you or another person. So this is what TuckerAllen's doing here is we're not giving a form away. We're saying come in, and what we do is prepare legal documents. We don't do forms. So it means that you're going to be meeting with a lawyer. It means that there will be a notary present to sign. So now, Grant, since it is free, it's not as if this lawyer can spend an hour in a session with you. So I don't want to misrepresent this, but you will be meeting with an individual lawyer who will ask you what it is you want and who will put that in a document, and there will be a notary there to sign. So it's an incredible thing to offer this thing free, and we're proud. I'm proud of TuckerAllen that this is happening, and I just want people to understand that it's not that TuckerAllen is handing you a form.
Right. It's very personalized. And mentioning the notary, I got to tell you, we had to have a legal document notarized a couple of weeks ago. And normally we would just go up to our bank. Well, with everything that's going on, the notary was only in there one day a week. So it was kind of a hassle juggling our schedules around this notary and going in there and setting everything up. So it's great that you can also get that done too.
Yeah, and we have witnesses too.
Oh, yeah, that's right. We have the witnesses. So, and that's one reason that we're having them call in, because I think, Teresa, when you and I first mentioned this, which was on this show about 2 weeks ago, we had said, well, let's just go ahead and let people come in between certain hours. We said, so you don't have to call, just come in between, say, 9 and 11 on a Monday and a Wednesday. Well, that didn't work because we have to really assemble this team of people to be sure they're there, because in Missouri you need witnesses, you need notary, and of course the lawyer has to be there. So with this lockdown, a lot of people are working remotely.
Right.
So we don't fully staff our offices right now. So that's the reason we have you call in. But keep in mind, this is only going on during the lockdown. We're doing it out of a commitment to the community, quite frankly. It's not profitable, but we want to do this as an expression of our commitment when TuckerAllen is committed to estate planning needs and personal health care needs for lawyers to serve clients. And what better way to express that than this? But there's also something else we're doing, or I think was just implemented very recently. What was that, Teresa?
Yeah, so this is pretty exciting. We just really want to make sure that in this time of uncertainty, people feel taken care of and that they don't really have many barriers in creating an estate plan. So TuckerAllen is actually offering 20% off to anyone who mentions this show that they heard about this offer, and that's 20% off of our estate planning services during this period of lockdown.
So all they have to do is call up and say, hey, I was listening to the ElderTalk show. I heard about this offer. Can we make an appointment? Sign me up. It's that easy.
Yeah, exactly.
Yeah, and we when we do things like this, I want people to know that it's not kind of an effort to market or just to offer something that is illusory, but rather to say, look, our mission here is to try to prove that during a time of great need that TuckerAllen stepped forward. TuckerAllen demonstrated its commitment to the community in a real tangible way.
Right.
So we try to figure out ways to be helpful that clearly represent that and don't appear to be some sort of marketing tactic. So we can't keep doing this. So we're only doing this during the lockdown. But what we just mentioned a moment ago about the powers of attorney, we're doing that. And separately, we're willing to do this 20% reduction, but it's only for people who are mentioning this show. In other words, we couldn't afford to do it to everyone that would come in indefinitely.
Right.
And we can only do it so long as this lockdown's going on.
Right.
But it's another effort for us to prove to you, the listeners, to demonstrate to you our commitment to the community.
And we've all heard that phrase, we're all in this together. So this is just something else, your organization's doing this to help those in the community get through this terrible crisis.
Yeah, yeah. And one thing that we also want to do is we want people to be aware that this is a time when you need to follow up on these legal matters. Each of you need to be sure that if you have a loved one that has not done this, a parent, that you're the only one in their orbit who will be in a position to influence them to perhaps move forward and do things that they might otherwise be disinclined to do, or perhaps they don't know they should do. Perhaps they're, for lack of a better word, feeble. And it doesn't mean they're incompetent. Remember, if they're incompetent, we can't do estate planning for them, neither can anyone else. But thankfully, that the way that term is defined is it's a very low bar to be competent.
I remember you saying that.
It's a very low bar.
Yeah.
When the law assigns levels for competence to engage in certain types of transactions, there's a range of levels. And interestingly, what I think is the absolute lowest in the law that I've been able to find is that of marriage. Interestingly. So Cordell would know something about that. But as to other things, for example, a competency hearing, for someone to be established as incompetent to manage for their care or safety by a court, that is a very low threshold. Meaning when you're going to rob someone of their ability to run their lives and appoint someone to run their lives for them, then thankfully we all should breathe a sigh of relief that bar. None of us would like to think that when we're older, we leave town and we come back and our kids have had us declared incompetent.
They've taken over.
But time has flown.
I
hasn't
know.
it? So I hope this show's been helpful. Teresa, we'll ask you to keep joining us here on the show and
Thank you for once again being with us,
giving us another
thanks for having me
perspective. Teresa Yao is an attorney with TuckerAllen. Till next time, this is Elder Talk. Take care.
You've been listening to Elder Talk with TuckerAllen, providing intelligent answers for those thinking about their future, with Attorney-CPA Joe Cordell. Sponsored by TuckerAllen, your estate and elder law advisors. For more information, visit TuckerAllen.com. Listen again next Saturday for another edition of Elder Talk with TuckerAllen. The choice of a lawyer is an important decision and should not be based solely on advertisements.